Right, good morning, everyone. The court has reconvened for handing down of an extemporary ruling in the matter of Bermuda Health Council against Dr. J.J. Soares and the Hamilton Medical Clinic. My Lord President.
Thank you all for attending. This is an interlocutory ruling by the court after hearing the appeal in this matter. We have reached three preliminary conclusions. They are: one, that the SHB Review Committee was not in error in treating the application as a mid-year application, and the September 2020 appeal panel was not in error in upholding that decision for that reason. Two, that the decision of that panel cannot stand because, based on Dr. Brathwaite's own evidence as to his participation at all stages of the proceedings, from the original technical and SHB committees up to and including the July and September 2020 appeal panels, and in all the circumstances, quote, the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the September 2020 appeal panel was biased, close quotes. See per Lord Hodge in Porter and McGill, 2001 UKHL 67 at paragraph 103, approved by the Supreme Court in Halliburton Company, brackets appellant, close brackets, v. Chubb Bermuda Insurance Limited at 2020 UKSC 48 at paragraph 52. See also Lord Phillips of Worth Matravers, MR, in Ray Medicaments and Related Classes Goods, open brackets number 2, close brackets, 2001, One Weekly Law Report 700, 726, para 83. 3, that nonetheless it was not appropriate for Mr. Justice Mussenden to take it upon himself to substitute his own decision for that of the September 2020 appeal panel. In the light of those conclusions, taken by themselves, and irrespective of and without prejudice to any further conclusions which the court might reach, given that, one, the order made by the judge at paragraph 133 bracket C of the judgment, reversing the September 2020 appeal decision and approving the application dated 6 March 2019 cannot stand, and 2, the September 2020 appeal panel decision also cannot stand, this court will need in due course to make orders and or give directions as to A, how in all the circumstances this appeal is to be disposed of, B, what, if any, relief is to be given to Dr. Soares stroke HMC, and C, what, if any, directions are to be given by this court as to the future conduct of Dr. Soares stroke HMC's applications. We do not, however, propose to make such orders and stroke or give such directions at the present time. In our judgment, the course that should now be followed is for this appeal to be adjourned sine die, pending consideration by the BHC of the extant full year application made by Dr. Soares stroke HMC on 30th of June 2020. That would mean the BHE considering it as a full year application, which does not therefore need to satisfy the mid-year conditions, on the footing that Dr. Soares and the HMC are not incumbent providers. Necessarily, they cannot fall to be treated as incumbent providers if the footing on which they became such, namely the decision of Mr. Justice Mussenden, cannot stand, even though that decision has not yet been formally set aside. In our judgment, this is the correct course for a number of reasons. The tortuous history of the various applications needs to come to an end. The best way of proceeding towards that end is for the full year application to be properly considered as such. If that is done and the application is granted, there will, we understand, be no problem arising from the fact that the application relates to the year 2021/2022, which is not that far from expiration, since if it is granted, the BHC will, under its current policy, treat Dr. Soars HMC as an incumbent provider, whose status will remain that for the 2022/2023 year. If the application fails, it will have failed after consideration of a full year application. If, on the other hand, we were immediately to set aside paragraph 133C of the judgment, rather than stating, as we have, that it falls to be set aside as in due course it will be, Dr. Soars HMC would find themselves in the position where they cannot lawfully provide the imaging services as an SHB, in circumstances where they might then find that when the BHC gets round to considering the extant full year application, Soars HMC is entitled to do so. This is not a satisfactory method of proceeding, particularly in the light of the past history of this case. When, or at any rate not before, the BHC has reached its decision on the full year application, the appeal will be restored for hearing, and this court will decide exactly what order to make. That will involve setting aside the judge's substitution of his own view. What is to be done in relation to the decision of the September 2020 appeal panel will be a matter for decision by this court. We shall deliver a judgment giving our reasons for reaching the conclusions to which I have referred and dealing with other matters in due course after the appeal has been restored for further hearing. So the order that we make at the moment is for the adjournment of the appeal sine die.
I'm grateful, my lord. I'm not sure if there's anything further I need to ask for or seek at this stage. I presume any issues of costs can be dealt with down the road, but
Yes, I don't think there is. Right.
Okay, thank you, my lord.
Thank you all very much.
thank you, my lord.